Friends, welcome to the 264th session of Legal Empowerment through Interaction lecture series. Today is a wonderful Sunday. We have our good old friend and family member, Anil Malhotra sir, addressing on a very, very important topic which is being discussed threadbare nowadays, surrogacy and adoption. And who else can speak on this topic other than an expert himself? And today we are privileged to have his daughter also joining us, Asta. Welcome, Asta, to our family. You are now part of the family. And before I thank anyone else, I'd like to thank Justice Muhamed Mustaque, sir, for introducing this wonderful speaker to this platform. In fact, he introduced us to this wonderful human being, friend, and a person who is a perpetual host for us in North India, because he has been offering us invitations, but COVID, now its variants are playing I'd say like they have been playing naughty, so that we are not able to avail that. But I am sure that we'll be coming there in a short while. We are privileged with the presence of Justice V. Ramkumar sir, Justice Ramakrishnan sir, Justice Kondaram sir, and all of you wonderful participants on this Sunday morning in the 264th session. So without wasting any time, may I request Justice Muhamed Mustaque sir to render the introductory remarks.
Well, good morning to all and wonderful new year. It's good to see many of our brothers here on the virtual platform. And the shining mustache of brother Ramkumar, he always called me as a mustache. So I would like to call him as a mustache with a black. Thanks to Godrej, brother Kondaram, brother Ramakrishnan. Malhotra has been baptized in Kerala now. So would be a priest for us and doing sermons all Sundays and Saturdays. Well, when I was asked to speak the introductory remarks on this topic, I know when a speaker is of such caliber would speak on the topic, I need not embark on such journey in this event. But still, certain things have came to my mind when you're debating on issues of this nature. You always frown upon the competency of the legislation, the virus of the legislation, etc. As a judge, of course, I have a sitting judge, I have a restraint on commenting upon those areas. But still, I just look upon the broader spectrum of the problem being presented today. After the fall of Roman Empire, it's always the problem for the state to legislate on a topic related to the autonomy, individual autonomy. Juxtaposing the autonomy and legal paternalism, always a contentious issue in the past. The philosophers like Immanuel Kant is outrightly rejected any form of paternalism. So absolute paternalism, according to me, is against notion. And he was against a kind of imposing ethical standards in legislation. Of course, the moral standards, according to him, is kind of having a universal acceptance in applications. John Stuart Mill, on the other hand, always, of course, championed the same cause, and he was also against paternalism, but bringing legislation which would prevent harm, of course, is the acceptable norm for it. Now, while balancing autonomy on one hand and legislators' competence to legislate and bringing legal paternalism through a legislation is something which is an onerous task and arduous task. That's what Malhotra's comment would be relevant. Today, the legislature have not such kind of skilled draftsmen. And that's another problem the legislature faces. Statesmen have no idea about the types of such as balancing needs in the era of technology, in the era of changing patterns of the requirement, changing patterns of the relationship. And British had such kind of skills. That's true in a certain extent. And another problem today is imposing super norms of international bodies, and we blindly accept such norms in a domestic level without considering the social fabric of our society. And Western society is more keen on individual autonomy, and their thrust is on individual liberty. And society like us, in a plural society like us, we are more focused on rights based on the society, and a more on homogeneous, creating an homogeneous society based on cultural identity. So balancing exercise is always problematic. So that's what I said for legislature, such a balancing exercise, autonomy and paternalism. This is really a problematic. In accommodating within the constitutional scheme, a certain skill has to be exhibited. And often it's happened in a democratic institution, governed state, because parliament has competence to legislate, and 3 or 4 judges sitting on bench decides its virus and striking it. And that's something where it's very goes to the very logic of a democratic governance. So how do we strike this balance? When you're discussing on a topic like this, on the surrogacy and assisted reproductive rights, especially based on the technologies, we need to consider the aspect relating to balancing exercise between autonomy and legal paternalism. No, here everybody knows there were a lot of problems arose in India because of India long permitted surrogacy, and I think it was banned in 2015. And many Europeans flew to India, create surrogate mothers, and there was an issue where issuing a passport in a foreign country, a foreign national, they refused, embassy refused to issue a passport, such a surrogate child, and Supreme Court intervened, I believe, and granted some relief. Now, those countries, of course, they have many reasons for banning it. India had not banned that time. Then it became more of a policy regulatory issues for the country. But there are issues of ethical standards. There are issues of moral standards. How do you accommodate within the scope of legislation? Perhaps that is something which need to contemplate. The commercialization of surrogacy is a key issue, but at the same time, there may be a required valid reasons how to balance it. There can't be complete banning of surrogacy. In a sense, the commercialization is possible. To what extent? How do you perceive it in the legislative scheme? What are the protocols to be followed, etc.? Similarly, in the assisted reproductive rights, where the technology is something which would enable many kind of assistance. What kind of protocol to be followed? What is the extent of intervention is possible by legislation without affecting individual autonomy? But keeping in mind, while deciphering on individual autonomy, we have to think about the Indian society. We can't look upon a Western society and decide an individual autonomy. We may fault ourselves. The standards, the ethical standards to be achieved in a particular level of a particular society has to be perceived within a society upon which legislator or state act upon, or state as a control. We can't look at an American society, we can't look at an European society and decide on autonomy in Indian context. Every society has its own moral standards and ethical standards. That is over a period we have developed through notions of culture, habits, practice, etc. So how far we can interfere with such standards? So that's where the real problem arises, while deciding on autonomy and in the context of legislative paternalism. Now, these standards we have in a society have perhaps in over a period evolved in certain manner. And every society has got its own ethos in developing a moral standards and ethical standards. And this is where the real problem arises for a legislator while enacting on legislations, as well as court acting on court deciding on education, and court trying to balance individual fundamental freedom with respect of within scheme of constitution. But often I find court attempt to blindly follow certain standards evolved in Western idealism or Western society. I think that's something which we can't, as a norm, cannot be accepted. We may falter ourselves in deciding our own notion, discarding our own notion of societal standards and ethical standards, and simply blindly following some standards laid in Europe. In Europe, everybody knows on collapse of Roman Empire, people have rejected theocratic society and to try to bring in a society based on rationalist and natural law principles. We have not rejected theocratic ideas. In the sense, we don't have a theocracy in our place, but certain level of religious standards have been laid on by followers of religion. and the main norm for governance within the society, the traditions, practice, culture. So when try to accommodate the constitutional norms, while trying to develop idea of notions of fundamental rights, we can't simply ignore the kind of standards of the society that has been followed. There would be inherent conflict when we try to develop such notions based on Western idealism. Whereas when you're touching upon the topic like this, surrogacy and all assisted reproductive rights, yes, commercial aspect, certainly we'll have to prevent it. But that again, coming ideas of notions of moral standards. The commercialism is something as a subject, it involves a subject element, somebody to assess in a particular context. So an individual would say that I have every right, I have a reproductive right as a woman, and won't belong to me. I have autonomy to decide what manner my home should be exploited. We would, based on the commercialization aspect, we may prevent it, regulate it, but what extent? This is something which we need a lot of thinking, a lot of deliberation. And I think today's lectures would give us some insight to it, especially Junior Malhotra, who is an academic now in London. She have more exposure to a larger world. And I'm sure that she will guide us. She will also guide us. Thank you.
Thank you very much, Justice Mustaque, sir. And with that wonderful introduction, I think the stage will be set by the daughter for the dad. So I request Asta Malhotra to render the topic analysis.
Thank you. So what I'll do today is briefly talk about the new Surrogacy Act. So in 2020, I co-authored a paper on reconceptualizing parenthood. And in that paper, essentially my co-author and I argue about how assisted reproductive technologies like IVF, surrogacy, even gene therapy, and also practices like adoption allow us to really separate the idea of giving birth from parenthood. Because more often than not in assisted reproduction, the person who does in fact give birth to the baby is not the one who parents the baby. And that separation is something that can be crucial for infertile couples or couples who choose to not have kids on their own, or single people who want to have children, or homosexual same-sex couples, transgender couples, and various other stakeholders. So we argue that the right to have a child is an extension of the right to have a family. And the context within which this happens is that while in India, the population is increasing, the rates of infertility are also increasing. What then ends up happening is, because infertility has so much stigma attached to it in our country, more often than not, the woman is the one who the blame is ascribed to. And as a result, it becomes extremely difficult for women to ward off the idea that they do not want to be mothers. And here is where the role of assisted reproductive technologies can become very, very important, because then it allows these women to sort of be a part of society and be a member of society as they had envisioned, and also as society expects of them. But what we see with acts such as the Surrogacy Act of 2021 is that there is nothing done to increase the access of this technology. It still remains something that is sort of only offered in private clinics. It's very expensive. It costs almost 16 lakhs to undergo one surrogacy procedure, and sometimes the baby may not even take. So I think firstly, it's sort of important for the Indian government, if eventually the goal is to encourage surrogacy, even if in a limited manner, to make it a part of family planning healthcare programs, to educate people about what their options look like if they're unable to have children. Is this an option only for infertile couples, or is it an option for people or women who have conditions like preeclampsia, which make it possible for them to have babies, but make it very, very difficult at the same time to have safe pregnancies? And I think the second aspect that's very crucial to the act is the fact that it outlaws commercial surrogacy. And it says that the premise on which it is outlawed is that commercial surrogacy can be very, very exploitative. What the act doesn't seem to realize, and what the act doesn't seem to envision, is that altruistic surrogacy can also be exploitative. And it can also involve huge amounts of coercion, huge amounts of force, for the surrogate mother. One of the earlier drafts of this act, when it was a bill, also said that only close relatives could be surrogate mothers, not really realizing that in an Indian family setup or an Indian family dynamic, to force a close relative to carry a child can be a very, very commonplace scenario. And what about the rights of the surrogate mother then? Why is that exploitation weighed significantly lower than commercial exploitation? The other thing that this act does is that it says that you can't advertise the practice of surrogacy. So a medical practitioner anyway cannot advertise, but you can't put an ad in the paper saying, looking for surrogates wanted. And you also simultaneously cannot say, I am available to offer my services as a surrogate. So then the larger question is, where do these intending parents go to find surrogates? And I think the simple answer is they go to places like Anand in Gujarat, to surrogacy hostels, where a lot of trafficked women are housed, and the exploitation that is carried on in these hostels is immense. And that's the kind of exploitation that the act should really sort of target, instead of completely outlawing commercial surrogacy. Further, the act only says that the medical expenses of the surrogate mother and insurance up to 36 months is accounted for in the whole agreement. But what the act also doesn't realize is that the surrogate mother also has responsibilities in perhaps her own household, perhaps has a job that she has to be out of work for just to carry this child, and also may develop certain medical conditions after these 36 months. So what happens then? Why is there no adequate financial compensation given to the surrogate mother at this point? And why is it that it's something that benevolent that she's expected to do just as part of the surrogacy agreement? And I think the larger question also is, why is the intending couple and the intending woman, the idea of that so restrictive? I think it's important to highlight that the intending woman, so only single, or not even single, but I'll get into that a little bit later, only women as individuals can undergo the practice of surrogacy. If a man wants to have a child via surrogacy, it has to necessarily be within a wedlock. But even for women, it's not just single women, as one would assume. There is still a requirement that the woman either has to be a widow or has to be a divorcee, which leads back to the idea that it is only appropriate for people or for women to become mothers within a wedlock. And only married people are able to realize or take care of a child in a way that a child deserves care. And I feel like this is very inconsistent, because single people are still allowed to adopt. So the Indian regulators and Indian legislators are in fact recognizing that single people can be good parents to children. But then those same it's not very consistent in how this is applied across assisted reproductive technologies and also adoption. And I think another very, very large stakeholder that is excluded is same-sex couples and also transgender couples, and also unmarried couples. Unmarried couples cannot have a child via surrogacy. And while the unions of these people are recognized by courts of law, unmarried couples are also given the status of married couples in various instances. So why is it that when the question is to have a child via surrogacy, all these considerations sort of go out of the window? Then NRIs, OCIs, people who have POI cards, those people are also not allowed to have kids via surrogacy, whereas inter-country adoption is allowed. So I feel like there are so many inconsistencies in the way in which this law is sort of applied that it makes it very, very difficult for all stakeholders to really reap its benefits. Then the other sort of important question that the Act intends to address but doesn't fully address is the commissioning of multiple surrogacies at once. So what the Act says is that someone who already has a biological child or a surrogate child will not be allowed to have another child via surrogacy. But in literal terms, this doesn't outlaw the practice of having multiple surrogates at the same time, because the child in the womb of the surrogate mother, the first surrogate mother, wouldn't necessarily qualify as a child until the child is actually born. So I feel like this is also sort of a gray area and can really allow people to misuse the provision of the law. Further, for the surrogate mother, I feel like there are very few considerations that are really kept in mind. Even things like aborting the baby. So the Medical Termination of Pregnancy Act allows for women who are carrying children to abort their fetuses within a stipulated time period. And you don't really need the consent of anybody but your own consent. You do not need the consent of a partner in advanced stages. Sometimes you need the consent of a medical practitioner, but that's not always the case. However, within this Surrogacy Act, not only do you have to consent as the surrogate mother to having to abort your baby, there also needs to be some kind of a permission from the appropriate authority. And I find this very, very, very problematic, simply because it doesn't envision what the consequences of this can be. What if the permission is delayed? What if there are serious health consequences that result as a delay of this permission? What if the permission is never granted? Is that just going to be sort of a rubber stamp where the consent of the surrogate mother is there and the authority is saying that, okay, you can go ahead with the termination of this pregnancy? Or is it actually going to be a scrutiny of the facts where the authority is going to dissect the medical case? If the medical case is going to be dissected, does this authority have the expertise to in fact do this? And what if the permission comes too late? And what if, as a result of an unsafe pregnancy, the surrogate mother unfortunately dies? What happens then? Is it the responsibility of the intending couple? Is it the responsibility of the intending mother? Is it the responsibility of the appropriate authority? No one knows. And I think that's sort of my larger problem with the act, that it is very, very, very short-sighted. And it doesn't really envision what happens to different stakeholders like same-sex couples, what happens to single people who want to have children via surrogacy, what happens to the child itself in case the child is abandoned, what happens to the surrogate mother in case anything goes wrong, right? And that's sort of the largest roadblock. So in our paper, we had sort of spoken about how regulation is important. And if in fact, the Indian legislators do decide to regulate surrogacy, we think it's a good step, and we think it's a step in the right direction, because without any sort of regulation, surrogacy hospitals, like I said, in places like Anand in Gujarat, were really flourishing, and there were very many malpractices that were going on in these clinics. But does regulation have to be so stringent that it chills the practice of surrogacy? I think not. I think there has to be a lot of flexibility, and there also has to be a sort of a transference of rights to the people involved, the medical practitioner, the surrogate mother, the intending couple, or the intending woman. All of these three people need to enter into an ironclad contract. And here is where the assistance of the courts can be very, very crucial. So for mediation, there are lots of drafts that are circulated by the government itself, where they say that this is an effective ironclad mediation agreement. So why is that something that cannot be adopted into surrogacy as well? Why can't you circulate an ironclad sample contract of that's tripartite in nature, where the surrogate mother is accounted for, the child is accounted for, the parents are accounted for, the medical practitioner's duties are sort of listed? And why is that not something people can build on? So that's sort of where I stand and the basis of my research in the area. Thank you.
Shyam.
Shyam, please.
No, a connectivity issue. It's all right now.
Yeah.
Yes. Thank you, Asta. And now that the baton has to be handed over to your dad, Anil Malhotra, sir, the relay has to continue. But I'm sure that, and in the meanwhile, let me welcome our special guest for the day, Dr. Ramaraju, sir, and of course, Mrinalini Deshmukh, ma'am. Welcome, and all of you. So, may I request Anil Malhotra, sir, to take on from this.
Thank you very much. Justice Mustaque's thought perception of the balance between rights, the role of the legislators, and the settlement of the proposition in a society of Indian nature is perhaps the fulcrum of this entire argument, and needs to be tested on the anvil of whether it is right or wrong. Now, where nature procreation is not possible, the options are adoption and surrogacy. Now, in the Indian context, what have we done to the laws on adoption and what have we done to the laws on surrogacy? Are we in tandem? Have we struck a balance? We have 15 million plus couples. I would not call them infertile. I would say who are unsuccessful in having children. They look for options. And my experience as a practitioner is people started opting for surrogacy because adoptions were very difficult. After Lakshmikant Pandey 1, 2, and 3, the adoption regulations came. Slowly they were modified. And the latest on the scene is the Juvenile Justice, Care and Protection of Children Act 2015, under which we have adoption regulations of 2017. So I will compare the law process, the law and the methods of law in adoption. To what extreme have they gone? And then I will see where are we on surrogacy in that context. Because in my humble view, these surrogacy laws, two of them, one, Artificial Reproductive Technology Regulation Act 2021, to regulate clinics and all other medical places working, and the other Surrogacy Regulation Act 2021 to regulate persons, are acts, mind you, of exclusions. Rather than telling you how to do it, they rather tell you, you cannot do it. So this is the extreme polarization in the two laws. Now, I think because these laws are imbalanced, they will ultimately have to be tested on the anvil of the constitutional laws. The Constituent Assembly on 26th of November 1949, which came into effect on 26th of January 1950, gave us a constitution in which we were promised a sovereign, socialist, secular, democratic republic with justice, social, economical, and political, liberty of thought, expression, belief, and worship, equality of status and opportunity, equality, and to promote among them all fraternity, ensuring the dignity of the individual, the unity and integrity of the nation. Now, in this context, I pause here. In the past 2 years, Parliament has been legislating laws telling you how to marry, when to marry, whom to marry, change the age of marriage, now how to procreate, when to procreate, under what conditions to procreate, and maybe some states even going to the extent of what religion should you follow, what food should you eat. So are we through law heading into laws of restrictions? Is the preamble of the Constitution and the justice, liberty, equality, and fraternity jeopardized? This, I think, is a larger constitutional question. And in the context of what Justice Mustaque said, we have to see, has the Parliament or the legislature balanced the rights, or has it upset the balance? Will courts have to step in? Now, in the context of surrogacy, flying in very briefly, I want to first look at the adoptions. Now, to see the extreme end, the Juvenile Justice Act 2015 in section 56 very clearly says, 57, it says eligibility of adoptive parents. It says prospective adoptive parent should be physically fit, financially sound, mentally alert, and highly motivated to adopt a child, and provide a good upbringing to them. In case of a couple, the consent of both spouses for the adoption shall be required. A single or a divorced person can adopt subject to fulfillments. a single male is not eligible to adopt a girl child. Now, the word very categorically used here is parents and persons. So there is no religion, there is no nationality, there is no stigma of your being single, divorced, LGBTQIA. This is a phrase which covers a lot of categories. So we have a secular, a sex-free, a gender-free, a choice available to us to adopt. And this is a law made by Parliament in 2015. Then we go to the adoption regulations made under Section 68 and under Regulation 4, we say Regulation 5, eligibility criteria for adoptive parents. Any prospective, now this is very important, adoptive parents, irrespective of marital status and whether or not he has a biological son or daughter, can adopt a child on the condition, namely consent of both spouses for the adoption shall be required. A single male can adopt a child of any, a single female can adopt a child of any gender. A single male shall not be eligible to adopt a girl child. So what have we done in adoptions? We have large number of children who are up for adoption. And this law was not created out of the hat. It took us 20 years to create this law under the nose and eyes of the Supreme Court in Lakshmikant Pandey's judgments. And slowly, consciously, and in a cautious mode, we decided that Indian children should go in adoption to foreign countries, to persons abroad, to persons irrespective of marital status. And we called them persons. We did not call them Indians. We did not call them married couples or etc. So what did the Ministry of Women and Child Development do? They created a central adoption resource agency under the guidelines. India signed the Adoption Convention of 1993 with The Hague, and per force India was obliged to incorporate all the conditions of the Adoption Convention, which meant that the welfare of the child and all the screening issues had to be compatible with the other countries where the child was going for adoption or coming from or for adoption. So we fell in place in an international network. We created CARA, Central Adoption Resource Agency. Now CARA has been elevated to the status of an authority. It is a statutory authority under the regulations of 2017. So CARA is now a Central Adoption Resource Authority. And what is CARA's job? CARA's job is to interact with central authorities of other countries. You enter into the database of a country where you are. They screen you, a home study report is made, it is sent back and forth. Then you are screened for availability of a child in the choice of the country. Once you are accepted, you are asked to choose a child in the adoption agency as per your seniority. Then there is a screening process, and ultimately an NOC is given by CARA. Then you have to go to a court to obtain a judicial order. Now, sadly, that has been reduced to an executive magistrate just to make the process simpler. So what has happened? A system has fallen into place to screen, check, sift, and decipher what and who is eligible for adoption. The bad eggs will be taken away, the good eggs will be permitted, and irrespective of religion, marital status, or your individual orientation of sex, you will be allowed to adopt an Indian child and take the child abroad. Now, there was another heavy bone of contention that under Section 56, if you adopted a child under HAMA, that is the Hindu Adoption and Maintenance Act, where giving and taking was necessary, CARA's process and the JJ Act did not apply. So There was a gray area because under Section 60 of the JJ Act, any child going abroad needs an NOC from CARA. So the Delhi High Court told CARA, you please make some guidelines. So the adoption guidelines have been amended on 17th of September 2021, and a chapter has been introduced for a procedure whereby children adopted under HAMA are to be given an NOC by a screening process through a district magistrate and ascertainment through state authorities of the adoption. So we have streamlined adoptions under HAMA also, so that children can go abroad to be adopted, because in Indian families, it is very common for a child within the family to be adopted by somebody who's childless and who's abroad within the same family. So this is where we are on the condition of adoptions. Now, it is in this scenario we move to what has happened in the law regarding surrogacy. It has taken us 12 years, 8 bills. And I think what we have come out with is a law, a restrictive law. I would think a law which has more no's and less yeses. Now let us try to understand Shafeen Jahan, 2018 Supreme Court 1933. Shafeen Jahan, Supreme Court 2018-19. Where is the Supreme Court thinking? What is the Supreme Court saying in the Indian society? Right to choose one's life partner is an important facet of intimate social relations and recognizing them. Puttu Swami, 2019 1 SEC 1. Promise of a right of privacy is embedded in Article 21 of the Constitution. Navtej Johar, decriminalizing homosexuality, 2018 Supreme Court 4321. Now, in this context, where the Supreme Court is going for a relaxation and liberalization of rights in a developing Indian society, though cautiously and slowly treading the path, where are we going in surrogacy? Now, let us step on to surrogacy. Now, if we go mythologically, you go back to Yashoda and Gandhari, you will find in our religious texts references of surrogacy. So the prehistoric urge to have a biological child with his own DNA has boomed into a 25,000 crore industry because we allowed it passively to grow. And then all of a sudden we came with a clampdown in 2012. But then what did it happen? The first and the only reported judgment with details of surrogacy is baby Manji Yamda's case, where a Japanese grandmother came to take her grandchild back after the couple had divorced. Baby Manji Yamda is 2008, 13 SCC 518. 2008, 13 FCC 518. Now this is the Justice Harijit Prasad talking of reproductive family camps, but he recognized traditional surrogacy, gestational surrogacy, altruistic surrogacy, and commercial surrogacy as 4 processes by which surrogacy took place. So I will deal with all this in 4 parts. So first we deal with the background of surrogacy. Then we see how surrogacy violates 14, 19, and 21. Then we talk of loopholes, and then we see what is the conclusion. So coming to the first part. Now, we started with the Indian Council for Medical Research guidelines in 2005, which, so to say, let the cat loose. Now, this is an administrative setup floating what are known as guidelines or some kind of administrative orders, but having no force of law, but it allowed a green flag to surrogacy. It was, these regulations were framed by a 15-member board of all medical experts, and with a lot of medical language, they said surrogacy is allowed, and it started moving. Then in 2002, as things went on, commercial surrogacy became almost legal for the lack of a law. But then we came with a clampdown in 2002, when immediately the government said, we are not going to allow certain categories of people, and there will be medical visas for people who come to surrogacy in India. Then we had the 228th report of the Law Commission. Law Commission said, prohibit commercial surrogacy, allow only altruistic surrogacy, and permit foreigners to do it. Exploitation should be prevented. Then came the bills 2012, 2014, 2016, 2019, select committees, and ultimately we have landed up with the 2021 bills, which the parliament passed, and very sadly, they were passed without debate because there was a boycott and there was no effective and real discussion on the issues. Now, the bone of contention is in the Surrogacy Regulation Bill 2021, Surrogacy Regulation Act 2021, which actually has come out with the law of restrictions. Now, Chapter 3 says, in second part, the eligibility criteria for intending couples will be a certificate of essentiality and a certificate of eligibility. So what is the certificate of essentiality? A certificate of medical indication in favor of both the members of the intending couples or the intending woman of gestational surrogacy from a district medical board, an order of parentage and custody of the surrogate child passed by a magistrate's court, an insurance of 36 months. Then is the certificate of eligibility. So what are these certificate of eligibility conditions? Couple should be Indian citizens. They should be between 23 to 50 years old for the wife and 26 to 55 years old for the husband. How they have come to these ages, I don't know. They should not have a biological child of their own or adopted child of their own. Then other conditions given by the regulations. Then third, eligibility criteria for the surrogate mother. Any married and willing woman between the ages of 25 to 35 years having a child of her own. Surrogate only once in a lifetime. Surrogate mother cannot provide her own gametes, and commercial surrogacy is banned. Only altruism. Now, I think getting these 3 certificates itself will take at least 5 years. And there will come up a regime of semi-qualified people, I don't want to use any other word, who will start procuring these certificates for a fee. So this is a major hurdle on the basic problem of this issue. Now, without going then as far as the Artificial Reproductive Technology Regulation Act 2021 is concerned, that is full of restrictions for the clinics. And I think if you read the whole of it, I'm not a medical expert, it says, rather than telling you how you can do it, it probably carries an unwritten message, don't do it. So coming on to this, let us come to the crunch which we as law persons want to look at. Do we bring in 14, 19 and 21 and test the surrogacy laws on the annual of the adoption laws made by Parliament? I am one with Justice Mustaque. We cannot import a European law, throw it in India, and start applying 14, 19, and 21. I am using a balancing setup between adoption and surrogacy in India, the dream of both of which is parenthood, to see, is it fair? Is it unfair? Does it meet the constitutional mandate? Are we following the preamble? We were supposed to be a democratically free-thinking society, and we were supposed to choose when to marry, who to marry, how to marry, at what age to marry. Now, I also see a comment by Mr. Sundaram in the Times of India. You know, it's a beautiful comment. I quote, "The exercise of the fundamental right given to every adult to cohabit cannot be delayed at the whim of the state." The argument that at that age the woman should study rather than run a household leads to a dangerous reasoning that the state can injunct a person from getting married without a stipulated education or being gainfully employed. Now, I apply the analogy in surrogacy. So we are deciding when you will have a surrogate, how you will have a surrogate, when will you enter surrogacy, who can enter into surrogacy. The bottom line is, who is the government to decide all this? It is my right. So therefore, we come into Article 14 to start with. So let us see what Minerva Mills said, 1980 Supreme Court 1789, Golden Triangle. Golden Triangle is to test the constitutional validity of a law enacted by Parliament. So first we come to 14. Now, Article 21, first 21. Now, 21 is right to life and right to personal liberty. Now, the first is, my right to life includes my right to a livelihood. There are women who are willing to be surrogates. You have to sign an affidavit. Your husband has to sign an affidavit. You are consenting to be a surrogate. You do it for the betterment. There are a lot of Indian women. I don't deny that there is exploitation. But then, can you restrict the rights of a surrogate who has a right of livelihood? Now, in Consumer Education Research Center, 1995, 42, SCC 3, CERC, Supreme Court said expression of life under Article 21 has a much wider meaning and includes right to livelihood. Then in Olga Tellis, Hawker's case, 86 Supreme Court 180, right to livelihood is violated if there is a complete ban. So if surrogacy is going to have a complete ban, the rights of women on a livelihood will be done away with. So this is one facet of Article 21, a right of livelihood. Then comes right to life. Now, Devika Biswas, 2016, 10 SCC 726. Devika Biswas, 2016, 10 SCC 726 says, reproductive rights of a woman include the right to carry a baby and give birth for raising. So my right to life includes my right of reproductive autonomy. Then we have Andhra Pradesh judgment, D.K. Parthasarthi, 1999. I used this when I challenged the 2012 guidelines. 1995, 5 ALT, Andhra Law Times, 715. It says, interference on the right of procreation amounts to a direct encroachment on the right to privacy and is a facet of right to life under Article 21. So my right of reproductive autonomy is my right under Article 21. You cannot take it away except by due process of law. And what is due process of law? It must meet a reasonable nexus with the object sought to be achieved. Then we have come on to a 9-judge constitution bench of the Supreme Court in Puttaswamy's case, 2017, 10 SCC 1, where we say that the privacy covers the personal autonomy relating to the body, mind, and to make a choice. So, a woman has a choice and a right to control her body, her fertility, and motherhood choices. This is Parthasarthi. Woman has a right to control her body, her fertility, and her motherhood choices. So if a woman decides she's going to give birth by surrogacy, and there is a law, it should be a positive law. It should not be a negative law, not a restrictive law. A regulatory law, rightly so, as said by Justice Mustaque. And we'll come to the comparison in the end. Now, let us step down to the anvil of Article 14. Article 14 guarantees equality of law and equal protection of laws. Now, Ashutosh Gupta, 2002, 4 SCC 334, 2002, 4 SCC 34, said that the test is there should be intelligible differentia and a rational nexus with the object sought to be achieved. Now, where there is no intelligible differentia and no nexus sought to be achieved, the differentiation is invalid. So, excluding NRIs, PIOs, OCIs, single persons, lesbian, gay. Now, this is a very interesting term: lesbian, gay, bisexual, transgender, queer, intersex, asexual. Now, these are terms which are not known to most of us because they are new generation terms. So, Q means queer, I means intersex, and A means asexual. Now, if you are going to take away the rights of all these categories of people who are otherwise eligible to adopt, are you not creating a violation of Article 14? Aim, goal, purpose, parenthood, method, adoption, method, surrogacy, method of adoption, controlled, checked, regulated, surrogacy, no, no, no. So if there is a person who wants to adopt, if a person wants to take through surrogacy, parenthood being same, purpose being same, one law allows, the other law disallows. What is the logic? Misuse. Why not check the misuse? Was there not misuse in adoptions? Were Indian children not trafficked and sold for prostitution and other unethical purposes? What did Supreme Court do? Supreme Court came in and said, make a law. Law was made. First Juvenile Justice Act came in 1995, then came in 2000, then came in 2015. So we developed a law, a regulatory law. We did the pluses and minuses. Now we next come to a very interesting phenomenon which the Supreme Court has which the Parliament has totally ignored. Now, as back as 2014, in National Legal Services Authority, that is AIR, 2014, Supreme Court 1863, AIR 2014, SC 1863, transgenders were recognized as third sex. And I was reading a law which probably most of us do not even know. This is the Transgender Persons Protection of Rights Act 2019. I'll repeat. Transgenders Persons Protection of Rights Act 2019. Rules are also in force. Act is in force. This act came on 5th of December 2019. Now, in the preamble, it says, an act to provide for protection of rights of transgenders and their welfare and for matters connected therewith. Now, who are transgenders? 2C. Transgender means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman, person with intersex variations, gender queer, and person having socio-cultural identities as Kinnar, Hijra, Yuravani, and Jogta. Then comes Section 8, Protection Against Discrimination. No person or establishment shall discriminate against a transgender person on the following grounds. Now, C is important: the denial or discontinuation of or unfair treatment with access to any provision or enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or opportunity dedicated to the use of general public or customarily available to the public. I pause here. Can you deny the benefit of surrogacy to a person who is a transgender or to a transgender couple? The question begs an answer. So in 2021, we are making a law contrary to what we did in the Juvenile Justice Care and Protection of Children Act for adoptions, and in 2019, a law for transgenders. Supreme Court said transgenders are persons. The Act says give them equality of opportunity. And further, Section 8 of this Act of 2019 talks of welfare measures by the government. The appropriate government shall take full and effective steps for participation and inclusion in society. Transgenders will be associated in welfare schemes. They should not be sensitized, stigmatized, or discrimination. Now, we have a movie going on in Chandigarh. Chandigarh Kare Ashki. I don't know if you've heard of it. It's a very interesting theme. It's about a transgender woman getting married, falling in love with a man, and at some stage before she's about to marry, she discloses to him that she's a transgender. Obviously, there is a lot of revolt in the man, but then when he's counseled, he understands, then he accepts her, and in the end, it is shown as a happy ending. This is the theme of the film. Now, if sexual orientation has been done away with by a law of parliament, why cannot surrogacy be done by a transgender person? If adoption can be done by a person irrespective of marital status, this means that I'm single, I'm queer, I'm gay, I'm bisexual, I'm asexual, I'm transgender. I can do adoption, but I can't do surrogacy. So, coming on further, let us come to Article 19 violation. Now, Article 19(1)(g) promises us freedom of trade and profession, and Article 19(6) says that this is not an absolute right, it can be regulated. Now, in Chintaman Rao, 1951 Supreme Court 118, Chintaman Rao, 1951 Supreme Court 118, it was said by the Supreme Court that the restrictions should be reasonable and should not be arbitrary or of excessive nature, so as to strike the interest of the public. So Article 19(1)(g) and social control under Article 19(6) have to strike a proper balance. We go still further. In Maharashtra, state of Maharashtra versus Indian Hotel and Restaurant Association, this is the dancers case, bar dancers case. AIR 2013, Supreme Court 2582. AIR 2013, Supreme Court 2582. Now, the Supreme Court said that the total ban on dancing in bars is unconstitutional because the cure is worse than the disease, because you are going to push women into prostitution and the right to carry on their profession under Article 19(1)(g) of the Constitution. Now, likewise, a complete ban on commercial surrogacy is totally unreasonable. Now, this brings me to the next part of what should we do? What are the loopholes and suggestions? Now, the loopholes and suggestions are, it's an imbalanced act. It talks more of restrictions. It contains more no's and less yeses. It tells you not to do it rather than to do it. It fails in creating a regulatory authority, a screening body to check, test the way you did in adoptions. I think what seems to have done in a perspective of a philosophy of certain thinking people of a particular segment of society, to stamp it out through law. So this seems to have been the exercise and the effort, and it doesn't meet the test of the Constitution. With the thinking in the Constitution, if you go through my TED talk, I say that India cannot afford to do surrogacy now. We have gone into it very far. We have allowed it to go on from 2005. We tried to stop it in 2015. 10 years have already gone by. Hospitals have been built. People have started doing this as a business. There are a lot of people involved for a question of livelihood. And it's better that we make a regulatory law. We screen people. We create a law of checks and balances. We streamline. We make a regulatory law and we proceed on. If we stop it, it shifted to Nepal. From Nepal, it shifted to Thailand. From Thailand, it has now gone to Ukraine. It's going to go on. So rather than accepting what to do, we'd rather allow it. And how do we reconcile two laws made by Parliament? One on adoptions, promoting adoptions, putting that on fast. Now, kindly see what we are doing in adoptions. We say judicial courts are taking very long to decide arbitration, to decide adoption petitions for an NOC. So we have changed the word from judicial magistrate to district executive magistrate. We want a fast track process. We want children under HAMA to get an NOC. We have amended the regulation. So we are on a fast track for adoptions. But insofar surrogacy is concerned, we are on a reverse track. We want to have more breaks, more roadblocks, and more stops. Can we reconcile inconsistent laws of adoption and surrogacy? Can we do away with rights of transgenders, particularly when Parliament is mid-law? It's a serious issue. Is Parliament not violating a law made by Parliament? You are giving a status to a person and asking his acceptance in society. But at the same time, in a very cloistered manner, in a very surrogate manner, I would say, you are keeping him out. What is the harm in a surrogate having a surrogate child? Gay people have it. So this, I think, is the whole analysis of how we have given birth to surrogate and adoption laws. And this is the critical analysis of the recent developments. So this, Shyam, is the long and short of it. I think Justice Mustaque lit the light very well by saying society, acceptance, Indian conditions, balance between constitutional law, societal requirements, and I would think constitution. Is it good or bad? Floor is open for views, thoughts, perceptions, and questions.
Thank you, Anil Malhotra, sir. As I said earlier, before we go to Justice Ramkumar, sir, we have a special guest today, Dr. Ramaraju, sir. We'll have your perception for a couple of minutes, sir.
Good afternoon, the legal fraternity. I'm Dr. Ramaraju. I've been practicing in the field of reproductive medicine since 25 years. And I strongly believe there should be a regulation. And we have been waiting for the regulation for the last 20 years. And second thing is, our societies have failed in self-guidance. When there's no self-guidance, then the government steps in and does what it feels and understands in the best interest of their understanding. That's my personal opinion. The second aspect is, when we look at the surrogacy and the ART bill, and you look at deeply more, and if you put the patient in the center of the field, that is the couple, then the need for a good quality assisted reproductive procedures with good amount of transparency is important. Next thing is, when it comes to the role of third-party genetic material, a reasonably good quality third-party genetic material is needed, and then the role of surrogacy comes in. But in India, we got mixed up with emotions of surrogacy, and then brought in the surrogacy bill, realized that that bill is inadequate, and then we brought in the ART bill. If you look at history across Europe, the 1980 Italian law was a very, very lax law. In 2004, it produced a law where it banned oocyte donation, sperm donation, and surrogacy, and also limited the number of embryos to 2 embryos. And this law was again revised in 2014 when they are allowed sperm donation, egg donation, and increased the number of embryos to be transferred in selected medical conditions. But still they have stopped surrogacy. So which procedure has to be done is an outlook, and there's nothing called right and wrong. And at least here we have a law which is saying that some amount of regulation and quality control happens in the area of reproductive medicine. And with time, as every law, it undergoes transformation and revisions depending on how vocal and how effective their argument is to modify the law by the respective scientific societies of the reproductive medicine. That's how I see the law. I might be wrong or right, but this is how I look at the law.
Thank you, sir. Thank you for the insightful comments. And let me just move to Justice Ramkumar, sir. Sir, your comments.
For a self-proclaimed and confirmed criminal like me, this was really enriching. And to hear Malhotra ji is like hearing an ultimate expert in the field. Now I have one doubt: how to check a surrogate mother from exploiting the would-be parents by threatening that if she is not given more money, she will abort the fetus by going to some private practitioner or some quack. How to effectively check?
I'll give you the answer straight away.
Yes.
See, people who have gone into this business, first of all, keep the surrogates literally in captivity, or they keep them in for 9 months in a home or the quarters or a building or a flat. 2, they make them sign agreements and they release the money in installments. A system has fallen into place whereby all this is taken care of. You are housed in a hostel or an apartment or a building where you do not have access to your family who can visit you periodically. Your money is released in installments and you are put to conditions. You sign a contract, you sign an affidavit, your husband signs an affidavit, and off the cuff, you hire muscle men and you hire all kinds of people to look after.
My goodness, her liberty is at stake.
14, 15, everything gives away.
At the end of the day, you are trying to get a nice child by indulging in all this.
I think there was a village in India, I think somewhere in North, there were a lot of surrogate mothers once upon a time.
All under solitary confinement.
Anand in Gujarat is called the tourism industry destination. You have packages bringing to India a reproductive tourism package, 1 visit to Taj Mahal and 1 free visit to Manali with your package, because you are charging in dollars. So all this is happening. Sir, a system has fallen into place. Lawyers, urologists, security staff is the better polite way of using the phenomenon. Gynecologists, then draftsmen.
It is more or less like a syndicate or a caucus. I think Dr.
So
Ramaraj wanted to add something, please.
So lawyers also are not excluded.
They are enforcing the agreement.
Yes.
Yes, no.
There was a case in Delhi. Somebody filed a suit for specific performance to enforce a surrogacy agreement because the person wanted a declaration from the court so that the mother wouldn't resile after 5 years. So it's not a declaration that the surrogate parents are the natural parents, because under Indian law, the commissioning couple is the couple entitled to surrogacy, unlike some other jurisdictions. This is the problem in the case in Gujarat, which is pending in Supreme Court. So that issue is still to be debated, but that is the way the guidelines were. But under the new act also, commissioning parents are the parents who are entitled.
Correct, sir. Dr. Ramaraj, you wanted to add something?
Yeah, I had a unique bad experience of being an investigative officer for a surrogate scandal where the doctor cheated the surrogate. And everything was recorded under video. and the testimony of the surrogate, the commissioning parents were recorded, the proof was there, but the file was kept like that for the last 5 years. So when our system is able to be manipulated like this, I think we need strong laws like this, and later, as we evolve better and become more responsible citizens, then we can have liberal laws. That's my personal opinion.
May I continue?
Yeah, Ramkumar sir.
I just may add something to what Dr. Ramraju said. You're able to hear?
Yeah, we can.
Yes.
We can't see you.
No, we can see also. No issues. Some connectivity issue is of course.
We are seeing
frozen.
him. Yes.
Yes, sir.
Okay. If a lady lends her womb as a surrogate mother, she is God's favorite. But if she were to lend some other part of her body for a living, she is dog's favorite. The universal truth is that while she cannot conceal the germinating seed for long, the male contributory can remain anonymous and can also conceal his identity. That is the natural God-given. A wonderful, excellent articulation,
Sir,
Mr. Malhotra ji.
the ovum donor can also remain anonymous. There are sperm banks and there are egg banks.
Yes.
To preserve eggs and sperms, they are not required. In fact, we had a movie also called Wiki Donor,
Yes.
where man has gone into business doing this donation business. So the sperm donor and the egg donor remains anonymous.
Yes.
The
But then
surrogate is made known. There is no choice. She only put it very crudely. The womb gives birth to the genetic material which is contributed by the parents, by one parent or none of the parents. So law shows anonymity as far as that is concerned.
have we succeeded on the medical side in having the womb itself transferred to a lab and the mother not having the conception?
We will need a Chinese expert on that.
We'll ask Dr. Ramaraju regarding that. Sir, have you
So that,
reached
the,
the stage?
so that the surrogate mother need not the pregnancy, the visible pregnancy,
Emotional.
disability, she can be exempt from that.
We haven't. I don't think we've got a Frankenstein as of now.
Let us say, Ramaraju sir.
When in 2004, the Italian law has come in, banning the oocytes of only 3 oocytes being used. That led to the development of oocyte freezing. So when there is a restriction, there is an innovation. Similarly, in the past 5 years, the uterine transplant technology has grown into leaps and bounds, and it's becoming a relatively safer procedure in the next coming years.
Is it what we call the test tube baby?
No.
No.
Where the uterus is transplanted, like the kidney transplant, the uterus. At this moment, the total number of procedures that were done are in less than 3 digits, and the number of children are in 2 digits. But with time, it's becoming a relatively safer procedure, but not a risk-free procedure. And that is where, when there is a huge restriction of this technology and the woman who really needs uterus, then I think this technology will step in, and a transplant surgeon from Pune 2 years back did 2 uterine transplants, which was supposed to be quite successful, and that transplant was 3rd or 4th in the world. So surrogacy
Technology is advancing.
I was thinking about
beyond
machine.
our thinking.
I was thinking about the heart-lung machine being having outside the body, like that. If the uterus also can be outside the body, the female need not undergo the.
Sir, I am very concerned why Justice Ramkumar is thinking of ordering a baby online or something.
Not at
No,
this age.
he is anticipating all these things and putting a
I don't know.
hypothetical question.
Never
Sir,
at this age.
Sir, I don't know why there is curiosity after question after question.
The curiosity creates the doubts. Okay.
Not kill. Not kill.
Mustaque, sir.
Yes. No, I just looking at that's what I'm saying. My brother Ramkumar tried to be young always. So this young mind always ask, provoke him to ask this kind of question.
Sir, we have Mrunalini Deshmukh ma'am with us, who had taken a couple of sessions similar to this subject. Ma'am, your comments.
Good morning, everybody. Thank you so much for making me a part of this. And my special respects to their lordships on this platform. Mr. Anil Malhotra, as usual, was exceptionally erudite, and he's articulated the laws, the limitations, and the regulations very well. But I think the cherry on the icing was Asta, his daughter, at such a young age. The kind of research that she has done, the kind of in-depth study, and the way she has articulated that in today's thing, I think she really, really, it's a commendable thing. And Asta, it's a brilliant job that you have done.
Thank you.
And
Thank you so much,
it's
ma'am.
really, really something which is incredible.
Thank
Now,
you.
having said this, and with a little bit of experience in the sense of practical experience in this, and I have been personally involved in drafting of an agreement and going through the process of one of the well-known personalities from the film industry who was a single father. And we had a lot of challenges at that point of time. And I'm talking about four years or 5 years back, when only the ICMR rules were there in sort of prevalent. And I personally got to see, and this is like a first-hand knowledge, as one would say, not only as a lawyer, what we hear from, is the way the document was articulated, was drawn up, the way the document was explained to the lady, the way it was even translated to her, because she was a Maharashtrian lady from Nasik, so obviously the language was an issue for her. And after doing all those things, as Mr. Malhotra rightly explained, that the payment that was, suppose it was 100 rupees that was supposed to be given to her, I'm just taking this as a number, they were paid in different tranches as per the number of weeks that she was holding the baby as a surrogate mother in things. In those 9 months or a little more than that, the way she was housed, the way she was taken care of, she was a mother of 2 children. She was just 26, but you know how there were early marriages in Maharashtra. And she was the mother of 2 children. Her 2 children, who were around 4 and 5 or whatever their ages were also housed in the same place where the mother was there, so that the biological mother and the children are not away. They were also taken care of. The mother was provided the best kind of nutrition and medication, etc. So also the children, along with the money which was there. And I personally, being Marathi, my mother tongue, happened to speak to her one-to-one. And I just asked her in a very, very frank manner, because otherwise everybody was speaking Hindi around her. And I asked her in my mother tongue that, are you really happy? I'm also from Nasik. We are from the same place, just to give her that familiarity and comfort. And she was said that I'm extremely happy what I'm doing. So I asked her, why would you be happy? You have your own 2 children. Why would you carry it? I was trying to cross-examine her. On which she said that I'm going to get an X amount of money, which she quoted the number at that point of time, and which I thought was a very, very reasonable thing. And she said, I have 2 dreams. I said, what is it? I want to build a house of my own in Nasik, a very small house, but my own house. I don't want to stay in a hutman. And I want my children to go to an English school. And that I can only do when I get this money. Now, this was something as a mother, it really, really touched my heart. And if this is what it is this exploitation? Is this commercial exploitation? I mean, I'm so sorry to say the legislators are so far away from the ground realities. And as Mr. Malhotra rightly stated, that exploitation could be even in altruistic surrogacy.
Correct, correct.
Exploitation comes from a power equation, whether that power equation is that of money or that of a position that is there in the family or in the circle that you are there. So if you want to do away with the exploitation, please have a set of rules and regulations which are there. But do not make this as a saying that you ban commercial surrogacy completely. Make altruistic surrogacy also. Because in my understanding and my limited experience, out of 1 million, there will be one who will be genuinely doing that. Out of 1 million, there'll be only one who will be genuinely doing an altruistic. And if the law has to have the letter and the spirit on which it has been drafted or being legislated, then obviously this ground reality has to be taken into consideration. And put your checks and balances is there, but do not make, and you cannot say, it is like, you know, the discussion that is going on in the Delhi High Court regarding the marital rape. There's some section of the people are coming and saying that there would be an abuse of the law if you have marital rape as a criminal offense, if you continue with that. And the lordships have rightly stated, if there is an abuse, doesn't mean you can't have a law in place. Now, if there is commercial exploitation, which may have happened, and I'm not saying no, which could have happened in a few cases, that does not mean you can have a law in place and put all the checks and balances. Make it a little supportive, a little more constructive enactment, rather than as Mr. Malhotra has said, no, only negatives, only don'ts. Where are the do's? I think I find no do's in the laws at all. So I think this is what my limited view is, and I thought I'll use this platform to express the same. Thank you so much for giving me this opportunity.
Thank you, madam. Do you have the freedom to reveal the identity of the film star father?
No.
I would not.
Okay.
I would not.
Better not.
Sir, it's public knowledge. He's from the Hindi film industry. It's public knowledge. But I would not be the person disclosing the name of my.
If you don't have the freedom, never do that.
No, it is against the professional etiquette for us.
It's the way I practice. It's just to keep as much. I mean, if social media goes, havoc with all these things. It's all over the social media. But I would not be the person to give the name of the client or the person that I was helping. Thank you.
Thank you. Yeah, please, Anil Malhotra.
I have also been a surrogate in drafting surrogacy agreements on behalf of XYZ, aged so-and-so, identity not to be disclosed, media baron, film star, no questions asked, just fill in the blanks and draft the agreement and send.
Okay.
Sir, you can only popularize as yourself, your Karan Johar or Tushar Kapoor or Sunny Leon. Otherwise, I don't think you can do it.
Okay. No, I thought that it is already public. No.
It is.
Well, well,
As a lawyer, she is not expected to. That's all what she says.
Exactly, sir. You are absolutely right. I'm not supposed to say the name of the client. There is enough material on the media for the same. But that is not the point. The point here is, what is the ground reality? I think that's what I was trying to say. And this, I can say it with a little bit of a sort of conviction, because I have personally dealt with the surrogate and the surroundings that were there. And her two words, that I want my children to go to an English medium school, was really a turning point for me. If that's what a surrogacy agreement or can give to a surrogate mother, that she creates a generation where they study in a good school, why not? This is not exploitation. Surely not.
I want to share my experience of Britain with what ma'am has just said. Britain has reconciled to giving reasonable expenses to the woman for the surrogacy to be undertaken. And Britain's law requires that before the child is handed over to the commissioning parents, the consent of the surrogate mother is to be obtained. So on behalf of an Indian couple who had divorced and who did not want the baby, there was a complication. So I was asked to go to a remote area in Punjab to find out from the surrogate mother whether she was consenting to hand over the child to the surrogate, to the commissioning mother or the father, in the circumstances of the case. So when I went there, I went to a railway colony and I found that this was an area where people from Bihar were living together in a cluster of huts. So it amazed me, what are these people from Bihar doing in this internal part of the city? So they told me, we are all families of railway gangmen who came from Bihar in the 50s and we have all settled down here. So I found in the courtyard 3 children playing, and this woman whom I talked to said, yes, I agreed to give the baby to them, but if they don't want the baby, just tell them to give it back to me. These 3 are playing and they will, this child will also be born and reared up here. I said, why did you do it? She says, it gives me money. And they were in the entire cluster of huts. Everybody knew that she had given birth to a surrogate baby. So ma'am is absolutely right. money makes the mayor go. It is all done with the acceptance of that family or the extended family or the society in which they live and its economics.
Very true, sir. Very. Can we have the comments of Ramakrishnan, sir?
Really, it's a area where, as Dr. Ramaraju has said, unless there is some restrictions on these aspects, there is a possibility of exploitation. So what is the extent of the regulation is required? It is a wisdom of the legislature to think about, one. Secondly, as he has rightly said, as time passes, if they feel that it is giving more difficulty for advancing the purpose for which it has been done, they can amend the laws also. That depends. And I want to close this with a cinema that has come. I do not know how many of them have seen it. In a Tamil film is there, Aviyum Anu. I think it came in Malayalam also. Deals with the same subject. Same subject, where the mother gives a surrogate mother gave birth to a boy. It became a boy. That's a different thing, but boy. And they were living separately without knowing these aspects. The boy fell in love with the daughter of that lady who is a surrogate mother. And ultimately, she was, without knowing the parents' permission, etc., they married. Ultimately, when they decided, she became pregnant also. Thereafter, when they came to know about the relationship with that, the mother, the surrogate mother, was not able to meet the shock. She died on account of some this thing. And there was some, what do you call, the discussion, pressure on the boy to leave the child, leave the girl and come away, because biologically she happens to be the sister of that, she happens to be the sister of that boy, because mother is the same. So ultimately the film ends in with that they decided to live together, because they feel that whatever rightly or wrongly they have tried to, because now the living together relations also very familiar. Right. So they close the film in a happy mood, stating that they can live together. They have decided to live together, and they also decided to procreate the child. And she had taken up the responsibility of looking after the child, saying that he accused the father and mother for that purpose.
Yes. Though prohibited degrees, factum valid.
So these are all areas where, taking into consideration of our Indian, as Justice Mustaque has said, Indian culture, you are thinking about these things, morality, etc., all will play to some extent to restrict all those aspects. So these are all the areas where we cannot give a what you call a straightforward answer or straightjacket answer as to this will not be allowed or not to be allowed. If it is allowed, what are all the restrictions and what will be the consequences of marriage comes between these two people, such a relationship. All those things are all an area where we will have to travel a lot. That is what I think of. It is a new legislation which has come. Let us see how far it will be helpful or not helpful, where it is required. Because once you say that there is no restriction, just like a prostitution become, because Bombay, it has been regulated. It is not allowed in other areas. If that be the case, why can't allow the prostitution everywhere with some restrictions which Bombay had? Legalize. That is not accepted. Legalize the prostitution. That has not been done. That has not been done, because there is a possibility of exploitation. Regulation will always be difficult. So all those things will not be taken note of, because depending upon, as Dr. Ramaraju has said, there is a possibility, because our culture or our attitude is not so civilized in fact, as in the case of foreign countries where you can regulate all those things, you can obey the laws and other things. So these are all the areas where we will have to travel a lot. Thank you very much, Mr. Malhotra, for your, and also I really appreciate the Asta who had coming up as a your generation and taken up this aspect in a better way, and also all possible things that has been put forward, what are all the things to be required for the purpose of making an amendment or all the things in a wider way. Thank you very much, and all the best, Asta, for your future.
You, sir.
Thank you.
Thank you.
Thank you, Justice Ramkumar sir. We'll have the comments from both Justice Kodandaram sir and Mustaque sir as well. Kodandaram sir, please.
Sir, it's a pleasure hearing Anil Malhotra and also Asta, both of them. In fact, I requested my daughter to join in the webinar, and she is there.
Good.
I'm sure that she is quite excited hearing Asta, wanting to get into law, not to get into law. She has been having so many questions. I'm sure that now she'll make up her mind fast.
Definitely.
And I also would like to thank, while thanking both of them, in fact, probably maybe we should also listen to Dr. Ramaraju more. Because personally, I know Dr. Ramaraju from probably from 88. We were friends from college days. And, my wife went through the IVF. He was one of the first persons in the country pioneering in the IVF concept. And he's been into research in last on various aspects. One aspect is that, while we talk about the commercialization or commercial utilization, etc., it's not that every individual is suitable for, or every woman is suitable for providing the surrogacy, or with regard to the individuals accepting. At this point of time, in fact, just like Sister Mrunalini and our Anil ji, I had occasion to draft a surrogacy agreement in 2004. That was the earliest point of time I did for someone, and they are very successful. And now the parents as well as the children, both of them are happy. The financial need of the individual and the opportunity to be able to experience. There are also unknown people who would like to have the experience without getting entangled into the marriage ties, wanting to have a motherhood, experience the motherhood. This is not a case where it is over, this contract gets over in a day or two. It's over a period of time. The emotional development and emotional attachment, the emotional aspects of the matter also, all of them will go into while selecting the individual. It's not that whoever is available on the road, you bring in them and then put them some injection and then make them pregnant. No. A lot of research goes inside behind the selection process. So our assumption or the lawmaker's assumption that there is going to be an exploitation and there is exploitation. I don't think that's really a basis on which one can act upon. While the judicial conscience or the legalistic way we look at the things may not really happen, may not really be applicable in the practical world. As in fact, Justice Rajendra Suchar has once said in one of the lectures that the legislature is 1 decade behind the society and the judiciary is 2 decades behind the legislature. That's the gap which we have. Because by the time it comes to the court and the Supreme Court, when the matter comes up in these kind of matters, probably the Supreme Court is to either way take it up and then they rather decide one way or other, rather than allowing, we would like to have the opinion of the High Court to start with. And opinion of the High Court takes 10-15 years, and by the time it goes to Supreme Court and gets self-be granted, leave granted, because it's a question of law to be considered and question decided, is 25 years. But by which time everything changes in the world. Now, everything cannot be tested in the anvil of the Article 14 or 21. And then leave the practicality aspect of the society to the winds and the legislatures, the so-called legislation, the way it is taking place, There's no discussion, there's no participation. Then question would arise, to what extent? Only one aspect I also differ with our senior Anil Malhotra is that the law is restrictive. When law is restrictive, what it means is if this law is only negative, it says negative, certain things to be not to be done. That means all other things are permitted. The presumption is that what has been prohibited is prohibited, that's all. You cannot impose the other things and you cannot imagine that these are all prohibited in one's own concept. That comes again when the judges are interpreting, they will add few more things. This is what my intention or this is what the intention of the legislature and make it more workable. That's my opinion.
Now, one more thing I want to say, we are forgetting about the right of the child, because really you are taking away the child from the biological mother. Suppose ultimately it came to know about that. What is the right of that child? Whether the contract between the parties binding on the child, whether the child can challenge it.
No. Child should be
How
able
can you
to.
say that it is not? It is a
Should
new
be able
question
to.
may arise.
Child should be able to challenge it.
Challenge whom? Challenge what?
Challenge
whom and what?
No, I can
Challenge
say
the
no, I want to
contracting
go,
parties.
I want to go back to my mother.
Regarding that, I think Mrinalini ji will have something to say. Yeah.
I see, as we all understand, is only for some of the junior lawyers who are there on the webinar. Actually, in most cases, of course, that could be an egg donor or there could be a sperm donor. But in most cases, what happens is due to medical reasons, etc., it is not possible to conceive a child in a natural way. So this is done in an embryo, and that embryo is then injected in a surrogate mother, and then so the biological parents, in most of the cases, I'm sure there are exceptions, and I'll come to the exceptions also. Most of the cases, these are the biological parents, where in this case, a mother is unable to hold. And I'm doing currently, as we speak, I'm doing 2 or 3 cases where the mother, due to her health reasons, is unable to hold the child. And she's got a first child, which is born naturally. Now she wants a sibling for the first child because she doesn't want to raise a single child, but she's unable to do so. And then she has gone for the surrogacy. So I'm giving you an example. So the biological parents in most cases remain the same. But what happens is in a single parent, for example, in the case of my client, he was a single father and a single person, and there was an egg donor. And then they had this embryo, which was then the surrogate mother took care of the sort of, raised in the womb. So in that case, the egg donor is an unknown person. It is supposed to be an unknown person. So for all practical reasons, the biological person is in this case, which I've given you, is the father. Or in most cases, it is the commissioning parents who are the biological. So there is no question of taking the child away from the biological. What you are really taking the child away is from a lady who has rent her womb for 9 months. If that is something which is against the child, I have no idea whether that could be taken as a cause. But in most of the cases, the child is not taken away from the biological parent.
No, madam, that is not the question. What is the emotional impact of the child in the womb? Whether it is that of the biological father or the surrogate mother.
Can I explain?
So the point here is the moment the child is born, just a moment, Mr. Malhotra, in most of the cases where the child is born, immediately within a week or depending on what the health of the child is, etc., is handed over to the commissioning parents. So where is the question of a child having anything which is there? Because most of the genes are that of the commissioning parents. The bringing up of the child is that of a commissioning parents. And in such cases, I mean, where is the question of a child's mental well-being or psyche or anything being affected by it? This is what I
put it another way also, because in a case where mother is not able to conceive at all, there is no possibility of the embryo being created and then being implanting.
Yeah, so
the father gives the sperm or the egg.
That's an egg donor.
Egg donor. If that be the case, that case come back. What will be the position of the person?
Ramashan sir, there is the confusion is this, Ramashan sir. What Mrinalini ma'am is trying to say is that there are 2 instances. Number 1 is the sperm and egg is someone else fertilized, and the surrogate mother only rents her, I mean, if I may use the term, the womb. That is what the topic we are dealing with. So what you are assuming or trying to say is that the surrogate mother acts as the mother in the sense like that is artificial insemination. It cannot be said to, that is, both are different, sir.
No, all this will be an incidental question. When surrogacy comes, how you get it is also a question to be considered. And what
We'll hear
Mr.
Anil Malhotra.
Yes.
Sir, let us try to understand. The genetic material is not contributed by the surrogate. So therefore, genetically, biologically, the genetic mother is the mother who has contributed the egg, and therefore the surrogate cannot be the biological mother. And as per the principle of surrogacy, the surrogate cannot be the contributory of the egg. So therefore, the surrogate has no biological or genetic connection with the child. Therefore, she has no rights on the child genetically or biologically. Now, if egg donor is the natural mother, there is no difficulty. But there may be a situation where the natural mother may not be in a position to donate an egg. So then in that case, the egg donor is a third anonymous person, not the surrogate mother. So you keep the identities complete. I have drafted a large number of surrogacy agreements, and in this, everything is very clear. The surrogate has no ties with the child. Putting it very crudely, she is only the womb or the vessel to keep the child or the baby for 9 months. She may, during the course of that period, develop some feelings or affections, but in law, in genetics, in biology, the terms, this will not result in any rights accruing to the surrogate. That's how it all goes. You cannot say that I have nursed the baby, so therefore I am the mother. That cannot happen, because neither the guidelines nor the act looks like this. But there will be questions arising on this issue also, and it will be a bone of
emotional, only emotional, is it not?
Emotional ties. And sir, on the question of the child wanting to know, we often hear of children coming from abroad after 20, 21 years and coming to say, I would like to know who my natural mother is. My child was given an adoption. When a person becomes an adult, he has independent rights. So he has every right to know. But at the same time, sperm banks and egg banks are under a total confidentiality provision. They are not supposed to disclose who was the sperm donor or the egg donor. You would probably need a court order. I don't think anything has ever come up, but still, nothing prevents a person from saying, I want to know who was the egg donor.
Correct, sir.
Also, Anil ji, in most of these cases, at least in Bombay and in metros, I've seen that working women, career women nowadays, it's very popular. They freeze their eggs because during the period that they are, the childbearing age, they have their career or things that they are growing, but they don't want to be deprived themselves of being a mother and having this. So they freeze their eggs, and then later on, these eggs are used if they have a partner or if they have a husband, and then it is injected in the surrogate mother, the embryo, and then thereafter the child is born. So today the law is developing as per the changes in the society also. I mean, that's what I would like to say.
Correct.
Well, these things are about urban metros. I do understand, and it's only 10% that constitutes urban metro. I completely understand that, but I'm just trying to give you the other side of the coin in reality.
Those small social patches. Let us hear from Mustaque, sir.
Thank you. Mrinalini has confessed that it's an urban perspective of sociological problem. She has illustrated a case of a woman who has faced an acute financial constraint, and she has to go the womb of someone. Now the problem is we are now discussing on a legislature and its validity or competency in interfering with the individual autonomy. Perhaps without discussing these aspects, we were not able to look at the legislation and scheme. Every law may have an impact on somebody's right or somebody's aspiration. An individual, like Mrinalini has pointed out, wants to come out from the poverty, and best option is to become a surrogate mother. Like Kantian, that's what I said, the Kantian philosophy says, categorical imperative. Every individual, every human is a free agent of his own will. And autonomy matters for that individual. And what is universally accepted become a norm as a rule. So for example, you should not kill anyone. That's a universally accepted norm. That becomes the rule. But point is, how a legislature should approach this kind of issue. Can an individual like Mrinalini's client could be a norm for a legislative subject, or larger perspective of the society, or ethical standards which a society is aspiring to? That should be the norm. These are something which a legislator always considers. So individual may have a lot of justifications. Individual may be a lot of necessities. How a legislator should approach the particular problem. Perhaps balancing different interests is always possible. It may have a different dimension, consideration, and legislature may attempt for a balance. The problem is essentially is a question: what kind of a society a legislator now aspiring within the scheme of a democratic governance? And legislator have a particular intention and particular standards. And people like the client like Ronaldi, which is who wants to come out from the poverty. Legislator has certain other scheme of empowerment. I mean, that's what the other social legislation taking into address. But perspective of legislation we have to consider. I think one lecture would be one of lecture series should be focusing on this: how a legislature to balance a different interest, societal ethical standards, individual autonomy, and etc. How to balance and accommodate within the domain of a particular legislation. Without addressing it, we may not be able to address many of the issues now being highlighted. That's what I believe. And maybe there are areas where legislators might have become oblivious or are not attentive to those areas. How to address those issues, in what manner those interests can be accommodated within legislatures. I've always said that there is some philosophical questions involved in this. As I said earlier, the Kantian ideals of rejecting a kind of legal paternalism and individual autonomy being recognized and universally accepted norms become the rule. There are many other concerns for state. A modern state, a lot of issues to be addressed. How to address all this within the legislative scheme, perhaps we need a more deliberation on it. That's what I believe. We can't simply look at one aspect and say that legislation is bad for that reason. Legislation can't be bad for a reason for particular individual finds it is difficult to accommodate her need or his need. And legislation has to be considered as whole. As Doctor has pointed out, it's a badly needed regulatory mechanism. Because in perspective, a doctor, he knows what is happening in the field, medical field, how medical doctors exploiting a particular situation. So this is one of the concerns in the modern legislation. How to accommodate plural, multitude of requirement in a particular domain of legislation. I think Shyam Padman's next session should focus on this.
Definitely, that is a wonderful idea.
And some legislation also be brought for such discussions.
Absolutely, sir. Thank you. And Doctor, you want to add something?
In the message, I've kept 2 review articles on the effect of the surrogate and the social implications on the child and the commissioning parents. These 2 are excellent review articles. One is in 2014 and another is in 2010. It gives us more meaning to the discussion we are having today.
Please share that, please.
Yeah, I already shared the thing on the thing. If you are not able to open it, I'll send the PDFs also. I've sent it in the message. Children of surrogate mothers, psychological well-being, family relationships, and experience of surrogacy is one article. The second thing is surrogacy outcomes for surrogate mother, children, and the resulting family, a systemic review. These are beautiful articles, the review articles. If you are not able to open the link, I'll share the actual PDFs.
No, I want to share one more thing, because is there any counseling provisions you are provided before entering into the agreement between these 2 people, and then the agreement is being entered into?
Even the surrogate mother, the would-be surrogate mother, as they say, is advised counseling, so that, and also her legal options in terms of, before she enters into the contract.
And not only that, pre-contract and also post-contract. Post-contract, both.
I don't know about post-contract, sir, but pre-contract, yes, I can say that. The counseling and explaining her the terms. Like I was saying, this girl was from Maharashtra. So obviously her mother tongue was Marathi. So she had a little limitation, not little, loads of limitation in understanding the language, the English language. So that is where it was required to be explained, to be taught to her in simple words in her own lingo, so that she understands the ramification. Counseling also then for her to understand what the things are. Because as you rightly said, sir, it takes a toll on a person. I can say as a mother, to carry a child and then, be just disconnected. But I guess that light of conditioning of the mind is to a large extent.
No, very easy to say that the sperm and other things are different. So mother will not get any this thing. The feelings of the carrying woman always will be there. And what I understood from the thing is limited knowledge of the physiology and other thing is that the child also will have some impact of those feelings of the pregnant mother in his characters also. Not only the genetic character, but also something will have some impact, because that is the reason why I said that at the time of marriage, the pregnancy, you should not give more attention to the pregnant mother, and that will have impact on the child. That will also have some impact on the character of the child, etc. I do not know. Doctor may be able to explain it.
Sir, my personal opinion is when we prioritize all the stakeholders, the unborn child is the first stakeholder, then the surrogate, then the commissioning mother. That's my personal view.
That we know, I want to know what will be the impact of the 9 months inside the womb of the unborn child, with the character or the period during which the child will have from the surrogate mother. Will it have any impact?
Ramashan sir is referring to the prenatal stage. I mean, that is before the delivery, during the pregnant stage.
During 9 months, it will be there in the womb of another person.
But if the child has not inherited any genetic material.
Sir, my personal opinion is we don't know anything about it. We are putting an embryo.
Yes.
We are putting an embryo which is size is 10 to the power of -4, and then it becomes a 3 kg baby. And we only know DNA, and we don't know anything about the RNA, the proteins, and its implications on the development of the child, and switching off and on of the different genes. Does the gene control it or the mother controls it? At this moment, we are completely ignorant on that domain, sir.
So some study will have to be done for that also.
Mrs. Mrinalini, I have one doubt. Can the same counsel who is the counsel for the commissioning parent be the counsel for the surrogate mother?
No, independent counseling.
There you go.
It is independent counseling only to ensure that suppose I'm a counselor and there is the surrogate mother, so that there should be free and frank, and of course it's a privileged communication, and the discussions are not disclosed to anyone. It is only to help her to understand what she is getting into it. So these sir, my suggestion was these kind of mandatory things one can put it in the act. Please go ahead, put it to avoid commercial exploitation or to avoid any kind of even emotional exploitation. But don't just have a blanket ban on it, and you're depriving a lot of people who want to have their own child. Life, etc., will come into place.
My experience in North India is it's signing on the dotted line. The poor woman.
Oh, that is really bad.
The poor woman who signs this agreement. You think you can understand it's a 25-30 page agreement. People like me. We try to put in things which people want to do. I had a person sitting in Bangalore who wanted to go to Ukraine because he somehow felt that his wife said, maybe if we go to Ukraine, we might get those blonde eyes and golden hair. And I said, listen, just to answer Ramakrishna, I said, your fertilized embryo is going to decide what color of hair and what color of eyes and what not. You won't get a white baby, so forget it. I said, you better do it here. Then he was very happy doing a surrogate here. In Ukraine, you have gold package, silver package, platinum package, and they offer you all. It's all on the internet. So what I'm saying is, the agreement is so complicated. Basics are understood. Bottom line is, how much money will I get, when will I get, and how will I get it? That's all. Counseling is all on paper. Effectively, you are kept in house.
Maharashtra is different. Some Maharashtra is different.
Maharashtra may be different.
In most of the cases, it is done as per this to give the complete knowledge to the person.
Because in Anand, Anand is a township where there are hospitals doing only this. It has developed. It has become organized. It has become a systematic place.
Institutionalized.
So, Amul is no more popular in Anand.
Sir, before we conclude, we'll take one question from Raj Vasantham. He wants to put a question. Please, sir.
Good morning. Good morning, everyone. The session was going on very well. It's a new area of it's awakening from my side. I'm a human rights activist from Indian Institute of Human Rights, New Delhi, living in Chennai. See, we are hiring a womb of a lady for birth. But legally, as Justice told, that there's nothing much rights of that surrogate mother. But the period of 9 months is a long time. And if any health issues happen, and at one stage she might have to die, then what is the legal impact? What will be the legal
Consequences.
points? Yeah, consequences.
On the contract, you mean?
Yeah, because will you put it in the agreement or what the law says about all that? Because the commissioning parents, they are responsible for the health of the child, the surrogate mother, including the child. So it's a very risky thing. So what is the safeguard? This is what I like to know.
To do an insurance policy for the mother. This is what the law says. See, the contract may be per se not enforceable because we have to go to the annual of the Indian Contract Act. So if it turns out that the contract is opposed to public policy, and because surrogacy was not allowed, then the contract will not be enforceable. But if the contract is enforceable, then you can enforce your rights under the contract. But the better way, the buffer way is now take an insurance policy. If something happens to the mother, then that insurance policy has to answer.
Now, Anil Malhotra, if it comes to the law comes now, because though it is restricted surrogacy is permissible now.
Yes, sir.
If that be the case, then only the contract between, because it cannot go say that it is against public policy under section 25 because it has become.
But my counter question, have we created these thinking? Have we created the thought process of people to handle surrogacy cases? If you are going to send it to a civil court, he will say, I have know nothing about it. Ideally speaking, there should have been a court designated as a
tribunal, specialized tribunal must be there to decide all those things.
Judicial training should be done in the academy.
Another tribunal.
It should be.
And then another bureaucrat will come.
I think you have to keep the bureaucrats out. You have to have a judicially trained mind. You have to then train these judges in the academy with specialists, medical experts, lawyers, so that they can handle the dispute. Sir, parentage, nationality, citizenship, there will be a lot of questions. It will explode all of a sudden. You have made the law, but sir, the act is totally silent about a remedy, appeal, and infrastructure. They have created boards, administrative boards. Now these boards are going to be packed with bureaucrats, ex-officio members who will not know anything from Adam. And the problem will come when people will start filing writs to take children out.
No, I think that the law only says about the certificate to be given, nothing more.
I also join with Anil Malhotra's sentiments because it's all right in drum.
My question is,
the right in drum can be only adjudicated through a judicial body. I think there is an inherent limitation with some other custom judicial function or some other bureaucrat turn to be an adjudicator or standing certificate. We can only decide on right in dispute in person or right in person. As far as the right in drum concerned, it essentially has to be a judicial body. That's what
No, Mustaque, can it be said it is a right in drum? It is a personal rights only because A and B.
No. As far as the contract is concerned, maybe a pursuit, but everything flows out of the contract is a right in drum. It has to be universally accepted.
Sir, succession, inheritance, property, declaration, they're rights in them, sir. Not in person. There is the whole world. Passport, American passport. What do you do? See, I personally think that they have created a law. They have tried to create a law to stamp out surrogacy with all no's and very little yeses. I disagree with the sir on this. There are very little yeses. It will take you years. And if somebody happens to do it and there is a problem, where will it go? Who will deal with it? Where is the court? We are already in a problem in domestic violence. We don't know where to take it. Should we take it to a magistrate? Will Supreme Court decide this? Then the next question is, in adoptions, they have brought it down to an executive magistrate. They are going to ruin the approval of adoption. As Justice Mustaque says, you have to have a judicially trained mind to give an approval to an adoption. You can't give it to an executive magistrate. So if you are going to appoint an executive magistrate to issue surrogacy certificates, then there will be an office outside his office whereby money will change hands and you start getting certificates. So we are actually created a system in surrogacy, which is still in surrogacy. The system is still surrogate. The law is still surrogate. You have to give birth.
Thank you. I think as we come to the end of the 264th session, let us hear from the newest family member, her experience of being part of this family before we conclude. Asta, anything to be added?
Thank you. So I think while the focus of this legislation has been to tackle the underbelly of surrogacy, what has inadvertently happened is that a new underbelly has been created. When you say that commercial exploitation is rampant and the law tackles commercial exploitation, I think what ends up happening is that you create many other levels of exploitation that are now becoming possible and are now going to become a lot more rampant. I think when you say that, earlier women were only doing this for money and were doing this for social mobility, now there is no social mobility at all. So who is going to agree to become a surrogate mother? And here is where ideas of how women will be trafficked and women will be coerced and women will be forced to become surrogates necessarily have to be dealt with. And I think that's sort of the basis with which all conversation and discourse on surrogacy must move forward. That's all from me. Thank you.
Thank you, Asta. And Mustaque sir, anything more to be said on this?
Thank you.
So
we will have more session with the junior Malhotra in the future.
Yeah.
We adopted him.
Yeah.
Let us make more of her experience before she is going
Yes.
riper.
No, we have an adoptive daughter also.
Our family is expanding. So,
Through surrogacy.
So let me thank Justice Muhammad Mustaque sir for introducing this speaker, and through him we could get the junior Malhotra ji also, and for rendering the introductory remarks, and Asta for a wonderful analysis on the topic. And as usual, Anil Malhotra sir, you were inimitable for one thing, and the way you could hold the crowd is something entirely different, and the mastery of the subject. Wonderful, sir. And Justice Ramkumar sir, thank you very much. Justice Ramakrishnan sir,
No, Anil
Dr. Ramaraju sir.
No, before finishing, Anil want to say something.
Yes.
Credit to Mudalini Deshmukh ma'am for having trained Asta for an internship for a good period in Mumbai and injecting very good thought process, which has actually seen fruit today.
We could see that spark passing on to her also. I mean, wonderful it is. And thank you, Mrunalini ma'am, for being part of our family and keeping in touch every now and then. That's really wonderful. And all of you, wonderful participants, thank you very much. And I'm sure that you'll feel that it's a Sunday morning well spent on a topic of relevance and importance. So till we meet again next week, let us have good thoughts, surrogate thoughts, and original thoughts. And till then, do take care and stay safe. Thank you.